Good afternoon. Please join us in welcoming Kathleen Morris, Professor of Law and the ACS Faculty Advisor at Golden Gate University.
Thank you so much. Can you hear me? So a couple of preliminary matters to get out of the way. If you would please silence your cell phones because we're video recording. The Twitter handle is at ACS Law. Hashtag ACS 2017. This panel has been approved for CLE credit, so you can check those details in the blue handout or ask ACS staff about that. And if questions come up for you during the course of this panel, please ask them. Write them on a card, hold the card up, somebody will come to collect your card and bring the card up to the dais. So I'm delighted to be here today. I'm going to introduce the panelists. I want you to know I'm going to be using first names. I'm not trying to be cheeky in doing that. I'm doing it just to keep things simple. So I'll start with Heather Gerken, who's an internationally known scholar and intellectual leader and the champion of the progressive federalism movement. And as of July 1st, will be the incoming dean of the Yale Law School, the first woman to hold that position. We also have Yvette McGee Brown, former Ohio Supreme Court Justice, first African-American woman to rise to that position, and currently a partner at Jones Day. Welcome. To Yvette's right, we have David Frederick, one of the nation's foremost Supreme Court and appellate lawyers, who's a particular expert in preemption and is a named partner at Kellogg, Hanson, Todd, Feigl, and Frederick. Welcome, David. And to Heather's right, we have Terry Goddard, former Attorney General of Arizona and a former mayor of Phoenix, which I love because he's straddling the state and the local on this panel. He's an expert in federalism and he teaches at Arizona State University. Welcome, Terry. And finally, we have Deep Gulasakram from Santa Clara Law School. Tenured professor, deep expert in immigration federalism. Welcome, Deep. So we're going to start with Heather, just kind of setting the table for us. And Heather, we're used to thinking about so many issues as federal: environmental health care, civil rights, reproductive rights, immigration, and so on. And just this week, we had three things happen that I thought were notable. One was the president announced withdrawal from the Paris Environmental Treaty, and within 24 hours, 10 governors and 61 mayors had pledged to uphold those commitments, which seemed new. We saw in China a meeting between the governor of a state, Jerry Brown, and the president of China, when in 2016, that meeting was the president of the United States and the president of China, not a governor. So that seemed notable. And then a third example was President Trump announcing a crackdown on sanctuary cities, which had caused states and cities to jump into the fray. And we saw the Justice Department, somewhat interestingly, retreating from their earlier position in a statement. So it seems sudden, but it's not sudden. As you know, because you've been working on this for 15 years. And so I wonder if you would place the recent events in a longer, broader context of theories of federalism.
Sure. Well, it's really wonderful to be here, and I'll just say it's really nice to be at a plenary session. It has been a long time since someone who talked about federalism has been at an ACS plenary session, hint, hint. So let me just say a few words about what I think is at stake now and what I think actually has always been at stake. Federalism is for everyone. I have been making that argument for a little while now. I find that progressives are much more attuned to that argument in recent months for reasons that you might imagine. But I just want to say to you, you fair weather federalism folks, welcome to the dark side. And let me just tell you, I want you to make this commitment enduring. So my hope is to convince you not only that federalism is for everyone, but it's actually a really useful thing. And so let me just be clear about what I mean by federalism. This is not your father's federalism. This is a completely different federalism. I want to tell you here are things that I believe, and I consider myself a pro-federalism person. I do not believe in sovereignty. I do not believe that the states have some protected realm where they can regulate free from national interference. I believe in the national supremacy trump card. Until about 2 months ago, I used to describe myself as a nationalist who believes in federalism. Now I feel like I need to clarify, a New Deal nationalist who believes in federalism. But states and localities are an enormously important part of our system, and I just want to talk a little bit about why that is so. So first, let me just put the thing on the table that leads most progressives to be against federalism, and that is the civil rights period. Right? That was a period in which states' rights were invoked in the ugliest way to deprive the rights of people within those states. So I just want to say to you one just thing to remember. We are in a different era. This is not your father's federalism. If the national government wants to act, it can. Despite all the efforts of the Rehnquist Court and the Roberts Court, they have simply failed to stem the tide of federal power. For every case that they have decided, there is an easy workaround, even for the one that was, for me as an election scholar, the most heartbreaking defeat, which was Shelby County. There is an easy constitutional solution if we want to revive the Voting Rights Act. It's just not a politically viable solution. So you have to remember, as you think about federalism, this is not the old federalism, where states are shielded from national norms. This is a federalism where we fight about national norms and national policy and national politics at the state and federal level. So the right way to think about federalism is not as some red or blue enclave isolated from the national government, which is what everyone is frightened about for federalism. You should think about this as the ground on which we fight. It's ground zero for the fight over national norms. And in that respect, they are incredibly useful if you care about equality, if you care about changing people's views. Why? Because they give you something that you don't have if you're just out there speaking and writing and marching. They allow you to put in place a real-life instantiation of your ideas. That is incredibly important and incredibly powerful. And for those of you who are on the ground, I don't need to be telling you this. Social movements have, for ages, used state and local policymaking as an opportunity to push forward there as ideas, to rally the troops, to move from a local conversation to a national one. The same-sex marriage movement is the most spectacular example in recent years, but there is example after example after example. I'll just tell you, if you are progressive and you care about progressive causes, the work has been done in the last 10 years at the state and local level, no matter almost what subject that you picked. So I just want to sort of emphasize it's not your father's federalism. So how should you think about federalism? You should think about federalism just like you think about everything else. It's a tool, right? And it can be used for either side. It's everybody's tool, and everybody should be using it. So I'm not going to tell you here that federalism is going to lend to progressivism or conservatism. It's not going to do either. It depends on who suits up and gets in the game and what they do with that power. But I just want to make it clear that we ought to be suiting up and getting in the game no matter what we care about. And so here's just the second piece I want to say. I think for a long time we've just made a mistake in thinking about federalism, right? We think about federalism as something that means it's anti-progressive values, it's anti-equality, it's anti-racial equality. That's just not true. The decentralization is not the reason why we have weak equality norms. It is because we have weak equality norms that we decentralize. So we decentralize when equality norms are not powerful enough at the national level for us to push it throughout the country. So that's what we do when we want to compromise on the norms, when we're not ready to stand behind them. And I've made this point. I had an interesting experiment. I made this point at Berkeley in October, and then in New York in February, where I delivered exactly the same lecture. I'll just say it resonated a little bit more when I said national equality norms are not as strong as you think they are, right? And that we need to fight for them. If you want to fight for them, the way to fight for them is to go to the state and local level. So that's the first way in which this is not your father's federalism. Here's the second way in which it's not your father's federalism. Sometimes we forget, although again the last 3 months have provided a pretty good reminder, that the federal government is actually pretty small and it's pretty weak by comparison to what it wants to do. What does the federal government need in order to enforce its policies? It needs states and localities. In many, many areas, it does not possess the administrative apparatus it needs to enforce federal law. We saw that under the Obama period. Just think about healthcare and ask yourself who was powerful in that process, the national government or states in those negotiations. And we're seeing it now when the tables have been turned. The sanctuary city movement is the most spectacular example. I'm proud to say that my clinic at Yale Law School, which has been around for about 10 years, helped litigate the sanctuary city order and won the nationwide injunction with the city of San Francisco. But that's just one example of how the federal government depends really heavily on states and localities. Think about marijuana. Federal law never changed when Washington and Colorado legalized marijuana. What changed is that the administrative apparatus that was responsible for 99% of the marijuana enforcement was withdrawn. That's how marijuana was it was quote unquote legalized. And you shouldn't think that the federal government has no weapons in this. The national supremacy trump card exists, but you just should remember when states and localities are as powerful as they are in the administrative structure, the national supremacy trump card turns out to be, as another scholar has said, a jack, not a king or an ace. So those are the two things I just want to say to you, but I just want to close with just one brief reminder. I think sometimes progressives make a certain kind of mistake when it comes to politics generally. We often like to imagine that whatever institution we've picked, be it the national government or judges, are going to somehow find their way to progressive causes. I just think that's a mistake. There's nothing that excuses you from suiting up and getting in the game. And I just want to encourage you now, suit up and get in the state and local game, because now it is time to acknowledge that this is all of our federalism.
So we have an incredibly wide-ranging panel in the way of expertise. And I know what you're thinking, which is, Lordy.
There's a tape. There's a tape.
How in the name of all that is good and holy is this panel going to be organized? So that's an excellent question. We had the same one, and we had to pick something, and this is what we picked. We decided to organize it by approaches or methods of pushing back against the federal government rather than by substantive topic. And that can be quite complicated because it's one thing for states to push back against the federal government, blue states against federal government. It's another thing for example, blue cities to push back against red states and the federal government at the same time. And if you can kind of close your eyes and picture that map that they always show on CNN or Fox or whatever with the blue and the red, one thing of particular interest to me as a city scholar is that I'm very, very worried about vulnerable people who live in our blue cities and our red states. What's going to happen to them if we don't get rid of Citizens United and political redistricting over the long haul? So that focuses me on cities. But in any event, the categories that we're going to deal with, and we'll take them, we'll do our best to take them one at a time, but we want a lively discussion, is four. 1, state and local legislation. 2, state and local government litigation. 3, state and local politics. And 4, we wanted to talk a little bit about the role of legal education and other forms of training in providing an assist in getting progressives into state and local government positions. So starting with legislation, by legislative solutions, we just mean the adoption of state statutes and/or local ordinances that push back against federal policy priorities in some way. And I want to start with DEEP because you've engaged so deeply with so many in your own scholarship, with so many of Heather's insights in the immigration federalism context, which is to say enacting state and local laws that address or impact immigrants. So I'd like to turn it over to you to talk about some of those examples.
Thank you for having me, and it's great to be on this panel, and thank you for the question, Kathleen. So I do think immigration provides a perfect example of many of the ideas that Heather was just talking about. There's been a significant movement at the state and local level on immigration on the progressive side in the last few years, but to really understand, I think, what's happening, you have to rewind the tape a little bit and think more broadly about maybe the last few years, last couple decades on immigration law. Immigration used to be a fairly bipartisan affair. You had legislation signed by bipartisan Congresses, signed by both Republican and Democratic presidents. But in 2001, that changes, that dynamic changes significantly. And in the mid-2000s, going into the early 2010s, you start to have a strong restrictionist movement at the state and local level. Prior to that, you had some movement, right? So you had one-offs like California's Proposition 187, but not really a movement at the state and local level. And you start to see that significant movement in the mid-2000s, led in large part by states like Arizona with its employer verification law, and soon followed by things like SB 1070. What's fascinating to me about that movement is that the way in which the political elites and entrepreneurs who were talking about those types of state and local laws, they were adopting the familiar tropes of federalism that we all know, right? This is about regional variation. This is about a federal government that is unable to enact laws. Therefore, there are public policy problems that present themselves that require state and local responses. And it turns out when you do the empirical sort of dive into these sorts of laws, which I did with a political scientist, turns out that story doesn't really hold a lot of water. That empirically, that's not that what I just described to you, those federalism tropes, don't do a lot of explaining as to why certain jurisdictions have these laws and why they don't. And turns out it's more easily explainable by a very simple partisan explanation. That is to say that, at that time, restrictionists being able to use the scaffolding of federalism to do exactly what Heather was talking about, that is to attempt to proliferate a set of national norms on immigration, which spread significantly from, if you look at the period from 2005 to about 2012, on the restrictionist side. In 2012, the Supreme Court decides United States versus Arizona, which some might say stopped that trend, and maybe you'd say the restrictionists lost, but I'm not sure the story's that simple. If one takes the long-term view, I do think that that movement, largely started by entrepreneurs like Chris Kobach, really changed the terms of the immigration debate. It made immigration restriction and enforcement a state-level issue. It changed the way national constituencies talked about immigration. It changed the way Congress talked about immigration when a comprehensive immigration bill came before it. After 2012, especially after the Obama administration's first large-scale deferred action program, DACA, Deferred Action for Child Arrivals, you started to see progressives beginning to adopt some of these same strategies. And that the progressive strategy mimicked in many ways that restrictionist trend. That is to say, you saw progressive enactments in places where you'd expect them to be, left-leaning states, blue states, and purple states and cities where you started to get these progressive enactments. You started to see things like, for example, driver's license laws for undocumented persons, professional licensing laws, college access and funding laws, and also healthcare and social services types of laws. And if you want to, the best example of this is just to look at the state of California and large cities within California, which have a variety, all of these things together, what you might call the California package of laws. You can add to this the sanctuary policies as well, which are slightly different in that they're mitigation efforts, right? You have federal enforcement and sanctuary laws attempt to mitigate that federal scheme, that enforcement program. But more broadly, I think they fit into that same narrative because I think sanctuary laws at this point are expressing a locality or a polity's views on the national immigration, on the legitimacy of national immigration enforcement. Here, even with those sanctuary laws, you see some jurisdictions adopt the classic tropes of federalism, right? This is about local autonomy. This is about the use of local resources. But I think it's impossible to de-link that autonomy-based rationale from what it's inevitably tied to, and that is these places are taking a position on the national immigration debate. And you can see this especially in cities that have very low immigrant populations, but nevertheless are very conspicuous about announcing their sanctuary policies. Or, for example, police departments, which have long had policies that mimic sanctuary policies, but now in the last year or two have named them sanctuary policies or have become much more conspicuous about it. And I think there's no way to read that other than to to note that they're doing exactly what Heather is talking about, right? That is to use their power as localities, to use that as the pulpit to change the way the national conversation on immigration law goes.
I just want to pause for 1 second to bring David in.
Can I just jump in? Because to me, the immigration issue creates a wonderful illustration of the complexity of federalism. Because if you take the basic concept of can a city decide who gets to immigrate to the city from another country, I don't think there's any real serious argument that the city can't do that. That's preempted by immigration laws. It's long been a field so pervasively occupied by the federal government that a city can't do that. On the other hand, could a city say, we want to provide education, healthcare benefits, housing benefits for people that are here illegally? Driver's licenses could be another example. I think that there's a lot more room for cities and states to provide services and to have areas of disagreement between each other as to whether they accept that. And so I think it's really important in this area of immigration, particularly where we're talking about state and local action in a sphere that has topically been pervasively occupied by the federal government, that we're sort of keeping distinct what are the classic discrepancies in the preemption doctrine, which are that traditional police, health, and welfare laws are typically devolved to the states, whereas certain things with respect to determining citizenship requirements or military, foreign affairs, and the like are for the national government. And so where I think Deep kind of puts his finger on some of these things, it's really important to keep in mind the structure of how our federalism is intended to operate.
Yeah, that's a great point. And I want to bring in Yvette because it's one thing, there's sort of two dynamics going on. One is that the federal government are, in a sense, coming after people or coming after certain things that are happening on the ground aggressively. Another dynamic that's going on is that the federal government is choosing to sort of drop the ball or not enforce things that have been historically enforced, not police things that have historically been policed. And Yvette has a particular interest in things like reproductive rights and federal curbing of police abuses and civil rights violations. And I think voting rights access is a huge issue, obviously. So I just wanted to bring Yvette in to make some comments about how legislation at the state and local level might be considered to address that.
Yeah, I think that, as you know, Jefferson Beauregard Sessions has said that, that he does not intend to bring any criminal prosecutions against police officers or to be very active in the civil rights realm. And so that pushes it back down to the states, and I happen to live in a blue city in a red state. And so part of the challenge, I think, for progressive lawyers are going to be to bring those litigations in the state courts. And if you live in a state like I do, you have a Supreme Court that is 6-1 Republican. You have a General Assembly that is overwhelmingly Republican. And so that's going to push it down, I think, to our local communities. And the reality is that you're not going to find a mayor or city official that wants to sue their police department. And so I think as progressive lawyers, the way that we're going to enforce civil rights are going to be using the civil courts representing plaintiffs in civil actions where there are those civil rights violations that perhaps people are not going to be held criminally responsible for. And if you live in a state where there are elected judges, the challenge is going to be even stronger. And so what I would encourage people to do is, as you're looking at enforcing whether it's reproductive rights, civil rights, is to look at your state legislature to clearly, as much as possible, have a voice there, but to understand that bringing lawsuits against whomever it may be that is infringing on civil rights is at least a way to get the conversation started and perhaps win some small victories that, even if you don't prevail in your state Supreme Courts, can at least set some precedents to keep bringing those cases back. It is not a good time if you live in a red state.
No, it is not. I want to sort of add 2 cents on the legislation front because I have been living and I worked in a blue city in a blue state, San Francisco, and before I became a professor, I was a deputy city attorney doing work on affirmative litigation. And one thing that I can tell you is that it's very damaging, I think, to the progressive movement for state-level officials to categorically resist arguments in court which grant cities certain powers, or to resist enacting legislation which grants cities certain powers. And I want to take a very specific example. In California, we have a very powerful law, Business and Professions Code Section 17200. And San Francisco has standing to enforce it. And it's a law that allows San Francisco to enjoin unlawful, unfair, and fraudulent business practices by anyone, an injunction, right? This is people of the state of California versus defendant X, right? The reason that's so powerful is that it gives an entity, it gives them potential, it has the potential to give a multitude of entities the ability to act kind of like plaintiffs firms, but without the money, without the financial incentive behind it. And so I think it's very important for state AGs and for state legislators to really, especially in the blue states, to really consider, let's take a moment and start creating opportunities for cities to get involved, especially in civil law enforcement, especially with the arbitration movement having taken so many things off the plaintiff's bar's docket and the cutting away at the class action movement, right? There's a potential essentially to create a nation of law enforcement, civil law enforcement units within city attorneys' offices and county council's offices. The reason that's so confusing is because when Yvette talks about civil rights laws being violated, what she's saying is the states are going to have to police some city officials. So you have some city officials over here, police and sheriffs and various other people who might be violating your civil rights. But over here within the same city, you might have people trying to vindicate your civil rights, trying to vindicate your consumers' rights. And so for some people, that's quite counterintuitive, but it works just fine. We do it in San Francisco all the time, and Los Angeles is doing it, Detroit's doing it, New York, and then places you wouldn't expect, like, necessarily like Gary, Indiana, Atlanta, and places like that.
And let me add one thing. If you're able to get diversity jurisdiction, remember that even in red states, there still are a number of Clinton and Obama federal judges. And so if you can get yourself into federal court to vindicate some of these rights. Now, if you live in Ohio, we only get a small victory at the trial court because then we go to the Sixth Circuit. But sometimes if you can get into federal court and pursue your action that way, you may be able to generate some success. Thank you.
So one of the things it means, of course, to become a new progressive federalist, if you take Heather's charge, is to understand essentially the threats and the possible counterattacks. So one big threat that I'd like to bring David in to explain is the threat, of course, of federal preemption. States and localities do things the federal government doesn't like. And to bring Terry in to talk about how we should all suddenly fall madly in love with the 10th Amendment for the first time in our lives and start really embracing those Scalia opinions that made us so angry when they were decided 15, 20 years ago.
So this is the CLE part of the program where we use the L. And the law here starts from Article 6 of the Constitution, Clause 2, which is the Supremacy Clause, which says that the Constitution, treaties, and laws of the United States are supreme, laws of the states notwithstanding, and the Constitution and laws of the states notwithstanding. And what Madison explained in Federalist 44 was that this was an important way of creating, I think, fundamentally the fabric of a national government. But notwithstanding the existence of the Supremacy Clause and its clear importance to the way our system is intended to operate, there is a wide range of room for states and localities to operate legally. But I think it's really important to understand how preemption doctrine works in its sort of superstructure. And so let me just take a couple of minutes to outline kind of what the basic principles are. There are essentially two forms of preemption. One is express preemption, and the other is implied preemption. Express preemption is when Congress writes a statute and it says we intend to displace state law, or to make it clear that the national law, as expressed through congressional statutes or regulations, are intended to be supreme. Those are relatively straightforward, easy cases. The latest that goes through these principles is a case that I argued about, well, not quite 10 years ago, called Altria versus Good. And that was a case involving cigarette labeling, where there was an express preemption clause. More often than not, what Congress does is it writes statutes that make clear that the federal government is intended to have power to do certain things, but it's silent as to what role, if any, the states are supposed to play. And this is the second kind of large form of preemption known as implied preemption. And there are basically two kinds of implied preemption. One is implied field preemption, and the other is implied conflict preemption. Implied field preemption occurs when historically the federal government has occupied a field so thoroughly that it is implied that Congress would have acted had it thought to do so. That's the example that I would give if, say, San Francisco wanted to come up with new immigration requirements for people coming in from Central America. This would be an area that if there wasn't a specific statute on the books, would be deemed to be field preempted as within a field that is so thoroughly occupied by the national government that there isn't room for the states to apply. The second area of implied conflict preemption really has really kind of crystallized into a simple proposition: is it impossible to comply with both federal and state requisites? And this is where all the action is, because there is another form of implied conflict preemption known as obstacle preemption. This was featured in a 90s case called Geyer involving passive restraints in cars. And subsequently, the court made clear in a case called Wyeth versus Levine about brand name drug pharmaceuticals and preempting state common law claims that obstacle preemption was going to take on a much less role in it, and it followed that up with a subsequent case involving the same kinds of passive restraints in that same time period. So the basic idea for impossibility preemption is, can you do both what the state government wants you to do, or what state law wants you to do, and what the federal law is requiring? And that is like classically looking at a clash. And where all these cases, and I've litigated a lot of them under a lot of different statutes, really come down to are, do the requirements that are imposed by state law create a duty that if you were to fulfill that duty, you would be running afoul of some federal principle, whether through statute or regulation? And so when we're talking about these various structures in all these various contexts, you know, the number one question is, did Congress say something about this? And if so, how express was Congress in wanting to displace state law? There are lots and lots of areas where there's a coordinate federalism, and labor is a good example of that. If you look at both public sector and private sector unionism, there are many states that permit it and many states that don't. And in fact, in the public sector union area, it's roughly half and half. The states that do not allow public sector unions are slightly more than that. But in my call to action for all of you, it would be to be cognizant that in your activism at the state level, it's really important for unions to have support by people that are not members of unions. As you are urging state action, the statistics, I think, are very clear that income inequality is less in states that have unions. The opportunities for people to come up who don't have college educations are greater if there are union opportunities. The training, the efficiency of services, and the like. And what's happening at both the legislative area is that this idea of coordinate federalism in a specific field of workplace equality, fairness, etc., is being lost, because the far right, which has property incentives to want to put down the opportunities for unions, have been so powerful that they've really dominated the discourse. And so my plea here is that there are areas that affect human beings in the same way that immigration does in these various issues, but affect people that have been citizens for a long time, and they concern the opportunities to work and get a fair and living wage and to be able to be protected by these kinds of laws. And there is a lot of room for state law to have an important role there.
I want to bring Terry in to talk a little bit about, whether you see space to the extent that the federal and the states have serious policy conflicts and can't get to yes to let each other do their thing, the extent to which there might be protections for states under the 10th Amendment.
Well, let me start with a preliminary. I want to welcome ACS back to the state and local arena, a group that has been very Washington focused, and I think for some pretty good reasons. But your initial premise that there were new things happening, like Jerry Brown meeting with the president of a country that was somehow radically new, is not true. I mean, state governments and local governments have been doing a great deal of hard work, pretty much unheralded, especially in the progressive community, for a long time. And they are truly the laboratories of democracy. They're where we can get things tried out in different ways, and hopefully it filters up to some kind of a national consensus. They have another, I think, critical role that is certainly not borne by Congress, and that is that they have to get things done. They actually have to balance a budget. They actually have to fix potholes. They actually have to make the trains run. Those are not burdens on the federal government in large part. And so some of the partisanship, and certainly I come from a state that has a lot of it, but some of the partisanship gloss that we see in Washington is not quite the same thing that you get at the state and local level. We used to say when I was in local government that there was no Republican or Democratic way to fix a pothole. Now, I would argue that sometimes there definitely was a Democratic way to fix it so that it lasted longer. But not the pothole, but the fix. But I think it's important to keep that in mind. Now, what we're seeing now is a remarkable change. And fortunately, a lot of national groups like this one have discovered that there are state officials on your side, specifically the state attorneys general. They're a small but robust group of Democrats that have done some pretty remarkable things in the past few months. Taking on the immigration order, making, in the case of cities, making the sanctuary city order hard to implement or impossible to implement. And I think there's going to see a lot more. And I think we're going to see what had happened somewhat in the Bush administration, which attorney generals going to the mat to enforce federal laws, especially against the Environmental Protection Agency and the Federal Consumer Protection Board, ones that apparently are not going to enforce the law that they've been given. So I think we're going to see very aggressive attorney general work in the next few months. I certainly hope so. I think we've got the right cast of characters, some very experienced and some very, very talented newcomers in that group, who I believe are going to take, and here's the important part, I guess, they're going to take the playbook of those who preceded them in the last administration. Let me just read you a quick quote. This Attorney General established his state's first federalism unit to combat unwarranted regulation and overreach by the federal government. He is a national leader in the cause to restore the proper balance of power between the states and the federal government. And another quote later on from the same Attorney General saying that we should never sacrifice liberty and the rule of law in the name of symbolism or expediency. Now, you may not have guessed that the Attorney General who said that was Scott Pruitt. And so in leading the fight against the Affordable Care Act and in leading the fight against the various executive orders on immigration, A.G. Pruitt and other advocates from the Republican side basically tried to use the 10th Amendment and other efforts of state power to basically hold up the federal government.
Well, you raise an interesting point, which is that, as people switch hats, the conversations get pretty good, right? So I wanted to bring Deep back in because...
Where you stand depends on where you sit.
That's right. I wanted to bring Deep back in, actually, because, of course, it's not risk-free to make the argument that, we should be doing everything we can at the state and local level, because that means everybody should be doing what they can at the state and local level, and the more you relax controls at the state and local level, the more when things happen at the state and local level that you don't love, you have less to say about it. And certainly we've seen that in the immigration context, as you've written about.
We have, Heather, do you want to?
No, go ahead.
Okay.
I'm just going to be disagreeable at some point.
Yeah, so I think, if you think about the sanctuary litigation, I think just a very quick point that I think might span some of the comments that David made as well. First of all, that litigation is really fascinating because it's not just about federalism, it's also about separation of powers, it's about access to courts, and it's about sort of process and practicality. And one of the things that I think is worth thinking about in that litigation is, broadly conceived, there's two sorts of categories of claims that one might make, right? One is that the federal government simply doesn't have the power to do what it's doing, that is to limit the way in which localities control their law enforcement officers, or to use heavy-handed financial incentives or coercion to accomplish that. That's one set of claims. And then there's another set of claims, I think this tracks with Heather's scholarship, is it's based more on the practicality, the process, and the interconnections between the state and local governments and federal governments, and the way in which that sort of dialogue can happen. That first claim that more directly puts into focus the actual constitutionality of any federal action that controls local law enforcement requires a fairly robust, strong, muscular version of the 10th Amendment, and it also speaks the language of sovereignty, right? That these lines are drawn that clearly separate what the federal government can do and what the state government can do. The second type of claim relies more on the notion that there are these connected areas where the federal government actually needs the state government and state and local government in order to accomplish what it's trying to accomplish, so we might want to be attentive to the ways in which that dialogue is happening. And I guess the concern that I would suggest progressives might have in thinking about that is that in using that strong version of the 10th Amendment, you are certainly doubling down on the idea of sovereignty. And I think that might have potential costs, right? Or at least ones worth thinking about. A strong anti-coercion, strong anti-leveraging principle, for example, grounded in the 10th Amendment. So, for example, using the Affordable Care Act litigation on the Medicaid expansion portion of it as the basis for making a strong claim against the use of financial incentives to tamp down on sanctuary cities, might have some long-term costs, right? Progressives, for the most part, I think in the wake of the ACA litigation, wanted to argue that the anti-leveraging principle announced there was quite narrow, right? Why? Because lots of federal programs that progressives like in the education arena, in the healthcare arena, are all premised on federal spending and the ability of the federal government to, for example, enforce Title IX through its spending regulations that are administered by agencies and monitored by those agencies.
And then on the flip side, there might be, conservative localities that are engaging in immigration federalism that progressives might not like.
That's right. And so if you look at, for example, right now, right, there's real life examples. So Texas SB 4 is a great example. Florida has a bill that looks very similar to that. Mississippi, Alabama, Georgia. Yeah, so Texas SB 4 is what you might think of as a state anti-sanctuary bill. So at the state level, it's an attempt to stop localities from enacting sanctuary types of bills. It creates liability for local law enforcement officers who have sanctuary types of ordinances. It requires them to honor detainer requests by federal immigration authorities, which, by the way, just last week, a judge in San Antonio found to be a violation of the Fourth Amendment when a person was held longer than the criminal offense, the state criminal offense would allow them to be held.
So I would like to bring in Heather actually to talk about, what do you think about this debate that I actually get this a lot as a local government scholar, that we can't have localities running amok doing whatever they want to, because what if we don't like what some American localities do, and so on?
Yeah, so I am having this sort of deja vu moment because I have gone to one Federalist Society meeting after another, and I look across a sea of lawyers and I say, you all are right to care about states, but you care about them for all the wrong reasons. And I'm worried that we are moving progressives into exactly this conversation. You're caring about states, but for all the wrong reasons. So I just want to emphasize under the be careful what you wish for category.
Right.
We should be careful in thinking about what we want to do at this moment in time. So if you're a lawyer, there's precedent. It is your job when you have a client to use it. You should use it. The Supreme Court has given us this precedent. Everyone should have it applied equally. That's all fine. But I just want to caution about be careful in thinking that we're going to lawyer our way out of this. That is, politics are what matter more. The reason why progressives are in the fix they're in is because they lost elections. They lost elections at the local and the state and the federal level. And this is what happens when you lose elections. And it's a mistake to think that law, and so we're all suddenly going to become 10th Amendment people, and that law is going to save us from it. The 10th Amendment is the same amendment that you all didn't like a year ago. And you should think a little bit about how much you want to use it as a tool. Again, I say this not to the lawyers who have clients, right? Because you have a job to do, but for the organizations that are sort of thinking about what they want to do in terms of movements, let me just say, politics, not law, is the solution here. States and localities are built to be powerful politically for all of these informal administrative reasons, but I just want to say a word of caution, because ACS is where I help. I was at Harvard. I was the first ACS head at Harvard. I'm delighted to have it, but I don't want to be coming here next year and saying to you, you care about states, and you're right about that, but for all the wrong reasons. So just please.
Well, I think it's important too to notice that there are different ways when we talk about policy. Policymakers need lawyers to help them build. So the last point that I want to make about legislation is that there are actually, I'm aware as a local government scholar, there's tons of policymakers at the local level right now who are clamoring for information on how to turn their local policy hopes into law when a red state tips blue. So a little over 4 years ago, some activists came to me and said, we're about to tip after like 15 years of work. Red cities in places like Orange County, California, Inland California, and San Diego County, California, et cetera, we're about to tip them blue. We have certain policy hopes and dreams, but we don't know how to translate them into law. We do need lawyers to be doing that kind of work very desperately. So their issue, they brought to us, universal health care, land use, transportation, reintegration of formerly incarcerated persons, creation of local human rights commissions, and so on and so on and so forth. How do we enact the laws to make this happen? So what we did at Golden Gate is we started a project where students take a hope and dream and scour the country for best practices and get the actual laws that were introduced, at the local level, and what agencies were created and how much does it cost to fund them. That kind of practical, kind of client-driven legal work is desperately needed right now, especially at the local level. So I just wanted to throw that in as a plea.
David had a comment.
Oh, please.
Well, I just wanted to echo and amplify on a point that Heather was making about the idea that federalism represents tools that, of course, the framers of the Constitution gave us to work out these political disputes and to figure out at what points power should be consolidated and diffused. And I would just amplify on the point about being careful about this, because as we are thinking about how to implement progressive values in laws at the national and local levels, we shouldn't lose sight of the fact that in the 80s, conservatives had a huge debate between the economic nationalists and the states' rights conservatives. And this debate played out over many, many years. And interestingly, when Justices the Chief Justice Rehnquist and Justice O'Connor retired and were replaced by Chief Justice Roberts and Justice Alito, you had two economic nationalist rights conservatives replacing two states' rights conservatives. And so this idea that Heather is talking about being, I'd like to be careful that as people in this room think about how you implement Federalist tools for progressive ideas, that we not get so caught up in these fights that we sort of lose sight of the fact that there's room in the Constitution for all of this. There may be states that have local policies or state laws that I might not like if I were to live there, but that's part of the constitutional design, right. And that
that's how democracy works.
That's right, and there is a way to change these laws, and going to the ballot box is an important feature of it. But that it would be a very, I think, unsettling thing if we were to kind of lose the momentum of focus on the importance of progressive ideas by fighting too much about, well, this can only be done at the national level or this can only be done at the state level, and kind of losing sight of the fact that we can deploy different tools through the federalism toolbox.
And one thing about it going so far to the right is that you do find strange bedfellows, so to speak, right? And so when it comes to women's reproductive health, you are finding conservative or Republican women who say, okay, this is a bridge too far, who will be willing to fight with you on a political front in states that try to go too far in, for example, completely cutting funding to Planned Parenthood and women's health clinics. And we should look for opportunities to partner with them when it allows us to make our cause and our effort more aggressively. Secondly, when you look at what's going on in many states because of the consequences of criminal justice, incarceration, you've got a lot of states who are now using this phrase smart on crime. And so there's an opportunity for progressives to really come in from a policy standpoint and help some of these states reshape the policies that have led to inordinate incarceration for drug offenses, low-level crimes, and for us to really be a strong voice there in shaping that policy. And so we should look for allies, regardless of what their political stripe is, as Heather says, to have a political solution to some of these problems that don't lend themselves well to a litigation strategy.
Yeah, thank you. It reminds me of a headline that I saw recently called something like, "When a red city mayor goes green." Mm-hmm. So we can't assume that we know that basically there's sort of like a ballot of policy, preferences that people will always have. Right. You want to give them space to help you. I mean, a lot of people came out of the woodwork during the LGBT marriage litigation that I would not have seen coming. And let them in. Come on in, Okay, so I do want to, I'm sorry, go ahead.
I was just thinking on your point, one of the great advocates for prison reform right now are the Koch brothers. Not exactly the ally of most progressive activities, but one of the perils, and I sort of suspect this in this group and other progressive groups embracing state and local government, is you've ignored it for so long. And it gets back to Heather's initial point. And the Kochs and others have moved very aggressively into this space. They've gone after city councils, school boards, secretaries of state, and attorneys general. And one of the reasons they're down to 20, when I first was elected Attorney General, I believe we had 34, 35 Democratic AGs. The number now is 21. So, and that includes the District of Columbia. So there is a definite change in the wind, and I think we've got to put that in the mix with everything else. I'm very pleased that yesterday ACS kicked off a state attorney general implementation effort where they're going to be able, this organization is, I hope, going to be able to provide some real world legal help to AGs who are very, very, very severely taxed from the resource side. And private attorneys can do a lot to help.
For sure. I want to actually circle back with Heather on the point about politics, though, and what you see as the most urgent kind of need to focus on politics at the state and local level.
Wow,
in terms of improving the democratic process. I mean, I'm thinking of the Democracy Index and improving the democracy itself.
Yeah, so I would say two things on the politics front. The first is that none of this works without elections working. Just think about Ferguson, for example. Ferguson was a majority black city, but because of a variety of problems in the election system, that black majority did not actually exercise majority power, and that's a huge problem. So nothing functions, none of this functions without elections working, and so campaign finance is a really core issue. The destruction of Section 5 of the Voting Rights Act is another core issue for lots of important reasons. But I'll just say the other thing on politics is, there is this thing called California. It is a super state. It can regulate the entire country simply by changing what it does for its own markets.
We also have a really good basketball team.
That really hurts.
I hope that hurt.
It did. It hurt with yes.
But it's
we got crushed last year.
Yeah. But it's a remarkable thing to be able to regulate in that fashion. And it's perfectly consistent with our system because we're such an integrated system. It's taking advantage of all the things that we care about if you believe in national power because they are integrated economically with the rest of us. But this is the kind of time to start thinking about spillovers. And mostly when you talk to lawyers, right, they get really uncomfortable with the idea of spillovers, with the idea that one state might regulate another citizens, right? It seems really uncomfortable.
Right.
I'll just tell you, spillovers are a good thing for democracy, and they, at this moment in time, if you are a progressive, they are a good thing for the progressive causes.
Good. And when we talk about politics, we're usually thinking of the executive and legislative branches at the state and local level. But as Yvette, you've brought up before the critical importance of judicial elections at the state level.
Absolutely.
So.
I mean, if you live in a state where your justices are elected, I mean, we have taken our eye off the ball. And I wanted to just follow up with Heather about Ferguson. I mean, think about what happened in Ferguson. And even now, after everything that's happened in Ferguson, they have less than a 30% turnout to vote. In a majority African-American city, they still have only elected one African-American official. So part of that, it goes into this thing about judicial elections. People aren't voting because we keep talking to ourselves. People on the ground are not feeling incentivized to get off their couch, be able to leave their jobs to go and vote. So when we're talking about elections have consequences, they also have consequences in the state judiciary because, as one of our Republican candidates said last year in Ohio, we are the backstop. She's saying that, which I think was a violation of the canons, but nobody agreed with that. So she's saying we are the backstop to what happens in this state. We have got to get people paying more attention to who we put into the state Supreme Court, because when those laws are passed, we need to have people with a diversity of thought who can apply the laws fairly and not be worried about what their Republican Party is going to say to them. And in every state that elects judges, it's critical that we focus on that and get some parity amongst our judges.
Thank you so much. Deep?
Yeah, I was just going to add, in addition to judicial elections, one of the things that's important in immigration, but also transsubstantively important in drug policy, in carceral policy, is going to be sheriffs and DAs, right? And these are elected officials in most places, and I think that progressives can make a lot of headway in thinking about how to influence elections for sheriffs. The ACLU has People Power, wallofus.org, Immigration Legal Resource Center are now starting to focus at that level because, if you don't think that sheriffs matter, just look at Maricopa County in Arizona with Sheriff Joe Arpaio.
I wish you wouldn't.
Yeah, absolutely. I actually have a small anecdote about that, which is that we have in San Francisco an elected treasurer. And when I was working on drafting the complaint with the city and county of San Francisco against the state of California on the marriage equality case, in case we lost the Gavin Newsom case, which we weren't going to do, but in case. And I was able to go to our elected treasurer and say to him, because the standing issue, right? Does discrimination against gay people cost the city money? And instead of saying, I don't have time for this, he said, let me get back to you on that. And he put a team of people on it. And then we had what we needed as lawyers in order to defend the idea that the city could, in fact, challenge the state's marriage equality laws, that we had standing to do so. And it's just very helpful. Like, you just never know when it might be helpful to have somebody who's elected in your corner. So I think progressives should just infest everywhere. That's my own personal view. Okay, so talking about more kind of, one might think like traditional legal solutions, litigation solutions, I just want to bring David and Terry back in to talk about attorneys general and thoughts about what AGs should be focusing on doing, what they are doing, what they should be doing, and so on and so forth at this time.
So there are a couple of categories of litigation. One would be state challenges when a federal agency fails to enforce the law. This is the classic Massachusetts versus EPA problem, where during the Bush administration, Massachusetts and a number of states felt that the EPA had not enforced greenhouse gas emission standards, and they brought suit, were found to have standing. That is a very interesting model for state AGs who believe that standards that were promulgated at the national level are simply not being enforced because of an abdication of responsibility. Another example of that would be the recent intervention by states in defending the Affordable Care Act, cost-sharing payment systems. That's another example where states can intervene because they have an interest in the way the federal-state financing of health care is done, to be able to enforce those kinds of federal standards in the event that the Trump administration chooses not to do that. A second category of litigation those are sort of, the federal government is abdicating its responsibility. There are these laws on the books, and states can step in to try to help make sure that those laws are enforced, and there are mechanisms to do that. A second category is when a federal agency tries to undo a progressive policy that would have been promulgated, in some past time, and in its unspooling of that regulation or rule, fails to follow the Administrative Procedure Act. And we have examples where the agency undoes something but fails to give a reasoned basis for the decision or the rule, or fails to provide by notice and comment rulemaking, or in one that I'll be doing in the DC Circuit, gets an inferior officer and violates the Appointments Clause in promulgating a rule. And so there are ways that states can take account of these legal requirements with respect to these various national rules regarding agencies. And the states have been very active in that space, and I've actually represented a number of states in doing that. And you can do this especially in the environmental space. Financial services, Dodd-Frank is an area that's very ripe for that. Consumer protection is an area where state AGs have long been leaders in the absence of a real robust Federal Trade Commission enforcement capability.
Terry, what are your thoughts on...
Can I add one thing before Terry? I mean, this is another proceed with caution, because to the extent about this administrative rule, the Obama administration did a lot of things without benefit of administrative rule, with these dear colleague letters and these policy interpretations. And I'm representing a local government right now that's being pummeled with something that was changed under Title VI with a dear colleague letter that we are probably going to go in and ask the court to not enforce, because it wasn't done under the Administrative Procedures Act. And so as progressives, we took full advantage of not using the Administrative Procedures Act, and I think now there's going to be a lot of unspooling of that, and I quite honestly think appropriately so. Yeah. We ought to have rules. We shouldn't be making dramatic legal changes by policy or fiat. I'm sorry, Terry.
Unless we absolutely have to. Okay.
Get rid of that exception. I'm suing the FAA right now for exactly what you're describing. But State Attorney General of Maryland, Brian Frosch, was here yesterday sort of helping to kick off this idea that ACS will be more involved with AGs. And he said, I really only have one word as to why you should, and that word is standing. Because in most of the issues that you've described, it's very hard to bring a private action, but AGs can do it. And they also have become very good at teamwork. And it started with the big effort to investigate and ultimately prosecute the tobacco companies. But since then, attorneys general around the country have found ways to accumulate or to share their resources. Most states couldn't do a major case on their own, but antitrust cases, for example, but they can do it as groups. And that's something that I think we're going to see a great deal of in the future. We've seen some in the past, but I think it's going to be revved up. The points that were just made in terms of environment and consumer protection are critical. Both the EPA and the CFPB have joint jurisdiction with the states. And I think that now we're going to see a whole lot more states taking an action in what in the Obama administration was clearly a federally led effort. And I think there's a danger too, and it's one that I sort of call upon you all to think about, and that is that every cause, every progressive cause, every just cause is not going to be able to be taken up by state officials. The whole issue of police brutality probably is not one that's going to be taken up by state attorney generals, nor is protection of the marijuana laws around this country. Most AGs, I hate to share this with this audience, don't agree with legalizing marijuana. But there are a lot of others, consumer and environmental in particular, where I think you're going to have a unified phalanx, especially on the Democrat side. The trick is going to be to try to move one or two, if possible, Republican AGs into that sector. The big deal that I'm worried about right now, and I think it's coming right away on the horizon, is that California's mileage standards for automobile vehicles, which is an overlap, is affecting all of our states and the production of vehicles, is, I believe, going to be challenged by Scott Pruitt, the same guy who stood up for states' rights just a year ago. I think he, as EPA director, is going to say, you can't do that, California. You have to use the same standard the EPA does, and that's going to be a class for titans.
Which is
Terry,
going to be a remarkable argument given the history of the Clean Air Act and the Clean Water Act, which were designed to be cooperative federal-state programs. I mean, the law is very clear that states have rooms. In fact, there was a long and much debated California exception back in the early 70s. So it's sort of ignoring history. Can I just add one other point?
They're good at that.
They are, well, but let me just add this. This is not a Democratic and Republican thing, because I do want to say that I've worked with a lot of Republican attorneys general who recognize the importance of protecting their states and doing certain things. And I would just, point out that Attorney General Mike DeWine of Ohio has fired the first salvo in the opioid crisis against pharmaceutical companies for the marketing of opioids that have created massive addiction problems and massive healthcare cost problems. Sure. And that's the kind of thing that we ought to be supporting and applauding. And
that will be a bipartisan effort.
And that's it. Yeah.
So I just want to pause there to bring Heather into this, because I'm curious about what intrigued you. I think that, we met 11 years ago at this very convention, as a matter of fact. And it really blew me away that you had any interest in this idea of sort of like a public interest law firm inside a city attorney's office, because already you were a tenured Harvard professor, you were moving to Yale. It's usually thought of as small ball, right? Anything to do with cities or localities or what have you, and I was used to that. What is it that interested you in that idea, and what role do you see city litigation in playing sort of generally in the democracy?
I do feel the need to correct the record. So MET is sort of a term that describes me walking off a podium just like this one at a plenary session when 4 people told all the students in the room that they should go do national policy work, and I told them to go to the state and local level. And as I walked off the stage, this woman took and she basically put me up against the wall like this as I was trying to get away to my plane, and wouldn't let me go until she finished telling me about the city of San Francisco, which has the near magical ability to sue almost anyone for almost anything on behalf of the state of California, as if they were the attorney general, thereby bypassing class certification and standing requirements. And didn't Yale law students want to take part in this? So in order to catch my plane, I said, yeah, I think they might be interested. And thus was born a clinic that has lasted 10 years, that is the most popular and hardest to get into clinic at Yale Law School. A generation of students has worked with the city of San Francisco to generate ideas for affirmative litigation and then to take part in the litigation itself. So my students have litigated the same-sex marriage case. They helped litigate the $1.1 billion with a B dollar lead paint case. They pulled I don't know how many all-nighters to be sure that San Francisco helped file the first in the nation sanctuary city order and thereby help win this nationwide injunction. Although I will just say the strange thing about being at Yale Law School is when I thought, wow, my students, it's a case of a lifetime to win a national injunction against the federal government. And then I realized, oh, there's 2 this spring for Yale Law clinics, so it's been a busy season. But the thing that's amazing about this clinic, and that I didn't actually understand when I had my blood being cut off because I couldn't breathe, but now, upon reflection, I have come to understand, is that the cities are like a standing army for enforcing civil law. And this is really Kathleen's vision and the vision of Dennis Herrera, the city attorney. They have a remarkable ability to do this work because they can speak differently for 2 reasons. So one, with all due respect to the state attorneys general in the room, they're much more nimble because they tend to be more politically unified than the states, and so that they can do more interesting things and they can do them more quickly.
We met in June, and in April, we had a thing.
Well,
This of the same year. That's how fast we were able to move.
Well, a thing might be somewhat ambiguous, kind of. So we had a.
I had to explain I was already
We're talking
married.
about San Francisco here. I don't know.
I was already. She got all these
clinic.
ideas.
Yeah.
So no, but we were able to basically get a clinic and a sort of a public interest law unit attached to Yale Law School done in 2 months.
But it was just the work that the students have been doing is amazing, and the work the city has been doing is because it speaks differently. So it could bring the lead paint case because city governments can do different things than private plaintiffs. It could speak differently in the same-sex marriage case because it wasn't arguing on behalf of the LGBTQ community, which was a great thing. It could also say, no, we're a city. Our city believes in this and speaks for this. So they have an amazing power, and I think that one of the hardest things to wrap your head around, if you care about structural reform, if you care about public interest litigation, is the idea that you've spent all of your time suing cities and states. It's actually useful to realize what has been a slogan inside the clinic, which is sometimes it is better to be the man than sue the man.
Very good.
Why don't law schools across the country pay more attention?
Well, so this is actually, thank you. That was a
state
perfect
and local
segue.
lawyers.
So of our last topic, which basically is what should legal education be doing? And I just want to say a couple of words about that. That we've got, in my mind, as a democracy, just as a democracy, we have a real problem right now, which is that we're not actually training up. We have 200 ABA accredited law schools. We haven't taken on the mission as law schools as a group of training up folks while they're in law school who can run our democracy. Except for, the Civ Pro and admin law, they take admin law, they take, con law. But state constitutional law isn't being taught from coast to coast. State and local government law isn't being taught from coast to coast. I can tell you I went on the academic teaching market 6 years ago, and what I was doing was really seen as kind of adorable but super marginal, and like they needed to hire, somebody who was doing something important. And I really think that that's quite troubling. And so I think we need more state and local government scholars to be thinking about the really difficult questions about state and local government lawyering. I think we need to be deliberately training up lawyers to run cities, to run counties, to run to get into state positions, and that should be kind of a third leg of what legal education is meant to do. Because if you think about it, we sort of think, okay, as professors, we're training people for the corporate world and we're training people for the nonprofit world, but we don't deliberately think, oh wait, there's this third leg, which is the governmental world, which is important not just because there are government lawyers, but because private lawyers deal with the government all the time, and often the government below the federal level is a bit of a black box to people. But we actually haven't decided to teach it, and so I think we should do that. What are some other ideas that law schools should be doing?
It's a black box to law schools, and especially the national law schools, but it is, as I think we made clear, it's where an awful lot of the action is happening and where a lot of good can be created. So I'm teaching, just in this last semester, a course on the ASU, at ASU on the law of the attorney generals and what they've done to change the national discourse. Jim Tierney, who's here somewhere, started it at Columbia. Jim, where are you? Hi. There, so right over there, the white-haired guy. But he is a former attorney general who's made a very popular course there. He moved to Harvard for reasons that are
but we need all
apparent,
the law schools to have
it's
it.
standing room only.
Right.
And
but
I think
we need
you're right.
all
There are
the
only
law
3 or
schools,
4
not some, right?
that have picked this up.
It should be a core thing in my mind, and I feel like every time I say that, it's very self-serving. But I happen to think that it's true.
Can I make
What's
a
the matter with
concrete
self-serving?
suggestion?
Yeah, sure.
Let's make law school less expensive. It's outrageous that law students.
Yeah. Okay, I'm not going to let us go. I'm not going to let us.
No, but seriously,
What does that have to do with local government?
The number one impediment to law students going out and doing public service jobs is they got these massive debts that they have to pay. So they've got to go and pay them off by going to corporate law firms and spending 2, 3, 5 years of whatever indentured servitude to do that in order to pay for their legal education. Well, no, but it's true.
I
and
enjoyed
so
my
you
indentured
want to have people
servitude. I
doing
ate
public
well.
interest make the legal education less expensive.
So the two, yes, thank you, yes, yeah. That's, of course, that's a panel, right?
Form a trust fund to pay for those folks who are going into local government.
No, but I mean, there's no reason why the cost of education has to be far greater than the consumer price index going up year after year after year.
Of course.
So can I make one pitch on this one? I mean, so the thing about ACS is that it's a highly networked group of lawyers, right? These are the people who are, it's an amazing organization. If you want to change things, you need to start changing things with regard to the students who are going out and getting jobs. And so I'll just say, so one of my favorite ideas that has sort of sprung up in the last few months by a former SFELT fellow named Jill Habig is the reason why a lot of people don't want to go into state and local government is that it's incredibly under-resourced, right? So the city of San Francisco pays DOJ-level salaries. It's a really attractive job, and it has plenty of resources to do the work that it does, in addition to a little standing army called the Yale Law Student Clinic. But the reason why other cities don't do that is because they're disempowered. They barely have enough money to do the defense work that they have to do. And so one idea is to start bringing young people in and funding them and turning them into little mini standing armies that you're inserting and providing the state AGs
Basically
and the cities
a pathway.
the kinds of support that they need, and at the same moment training a generation to appreciate it. If you want to change things, you have to start there.
So our former student and wonderful colleague Jill Habig, Heather just mentioned, is starting an organization called publicrightsproject.org. Public Rights Project, publicrightsproject.org. Jill Habig, where is she?
Is Jill there? No?
Oh, there she is. Hi. So essentially, it's like, you know how the Skadden Fellowship Program will fund for 2 years your ability to graduate law school and then go straight into public interest? And that one of the things that's valuable about that is that you get the training you need to get a job, because everybody says, well, if you don't have training, you can't get a job in your field. This is going to be that for progressive public lawyering at the state and city level. And also, she's got all kinds of ideas cooked up about how else they're going to advise and support cities and states that want to do progressive work, progressive litigation and policy work, and God only knows what else she'll get up to, but it'll be a lot, whatever it is. So check out publicrightsproject.org. So thank you so much. We're going to take some audience questions. Thank you for your questions, whoever sent them. So first question, David and Heather cautioned about relying on the 10th Amendment and other Federalist tools. Could they expound on some cautionary tales that explain why we need to proceed with caution?
Yeah, I'll just say, I think that what's behind current 10th Amendment doctrine is a completely wrong-headed understanding of what states do. So the old 10th Amendment doctrine is tired and it's incorrect. It's based on this idea that we are these red and blue enclaves that need to be protected from the federal government, that there are 50 laboratories of democracy all generating ideas and they need to be shielded from national power. That's wrong, right? There are 2 labs, one is red and one is blue. You can rethink constitutional law to imagine protecting a robust democracy and thinking about what to do about those 2 labs to make sure they flourish. You can think about what you want to do to make sure that when the federal and states tussle, which they do all the time, that the conditions for that tussle are fair, that both sides are equally sufficiently powerful to do the jobs that they do. But to go back to this completely outdated notion that we want enclaves where the federal government cannot interfere, that's a mistake. It's a mistake for our democracy. It's certainly a mistake if you're a progressive. I keep telling conservatives it's a mistake for them too, but it's also just, as a factual matter, incorrect. So don't endorse that vision of the 10th Amendment. If you want to talk about constitutional protections for states, you should think about it in the way that it exists now, which is the states and federal government are regulating shoulder to shoulder. Sometimes they're leaning on one another. Sometimes they're deliberately giving each other a shove. We have cooperative federalism and uncooperative federalism. If you want to think about building a doctrine, build a doctrine around that, which is not only true, but is a far more attractive understanding of federalism than the one that we have from the past. So that's my pitch.
My pitch would be there are certain subject areas that states are just not very well equipped to be regulating. And if you look at things like nuclear power or banking that is national banking or international banking, or if you look at the regulation of international shipping, I mean, there are just certain things that the national government is equipped to regulate and deal with that state governments are not. And so the 10th Amendment, I think, is got to be viewed as a way of balancing the power structure of the Constitution, and Article 6 and the 10th Amendment kind of stand in a certain equipoise where the fighting goes over which are going to be better equipped to deal with some of these kinds of problems. And so, too robust an interpretation of the 10th Amendment denies the strength of national power for some subject matters that are quite appropriately done best at the national level.
Thank you.
Yeah, but it's still a critical bastion against federal overreach, which I think you get in a lot of areas. We used to have a rule in our legislature that the folks above you on the legislative, in other words, Congress, were always trying to usurp your power, and the people below you needed to be watched carefully and chastised every time they got out of line. But the bottom line is standing up against the feds as a state is, without the 10th Amendment, is almost impossible. So we need that little bit of background where what has not been specifically delegated to the federal government is reserved.
Yeah. So here's a good deep question. Is there a neutral principle distinguishing normatively bad federalism, like state religious freedom acts, from normatively good federalism, like state or local environmental regulation? Of course, this is a leading question. Is there good or bad federalism? I'm reading.
So actually, I'll get to that in just a second. I'm not sure I agree with Terry's your answer to that last question. I'm not sure that it requires such a strong version of the 10th Amendment where you can say that there are reserved areas. I think a point that Heather has made in her scholarship, but is also evident just looking at all these different areas, is that because of the shoulder-to-shoulder regulation, there are lots of ways in which states exert leverage on the federal government without that strong enclave sovereignty sort of principle. And I do think that that's where that progressives have to be careful. The stronger you push on that enclave area, I think that's where we may it's not clear that you don't want to, but that's, I think, where the caution is, which gets to the question that was asked.
Shoulder to shoulder is an awkward position when one shoulder is so much bigger than the other one.
I think that's true whether you have the 10th Amendment or not. That you have the supremacy clause, and I don't think anybody is going to make the argument that once the federal government robustly enters an area, that that state law can then nullify that federal action. But the fact is, a lot of important areas of federal regulation rely on state and local administrative structures in order to make them happen. And that creates significant mutual leverage between those two levels of government. I don't know if Heather, you wanted to
preach.
But to get to the question, so so I'm not sure I have a lot to add to say about the question. I think that the question sort of answers itself. I don't know of a good neutral principle other than to say that probably depends on where you stand on the political spectrum, which is why politics matters so much.
Well,
we only pass good laws and not bad ones.
That's right.
Well, that's the thing, is that when I first made the move from public interest lawyer to city attorney, I got a lot of pushback, and sometimes I still do, actually, from my sort of more traditional public interest friends, because they felt like I was now working for the enemy. And I thought, well, no, it's not. There's nothing inherently evil, right, about cities. When cities do evil things, it's because of the people who are there. So we have to be the people who are there. And not the other side. So here's a great question. What is the possible role of federalism in campaign finance reform, which seems like the most paramount issue of our time?
Amen.
Heather will have nothing to say about this, I'm sure.
I mean, campaign finance reform, we were trying not to be too depressing for this panel. It's a disaster. And I'll just tell you, it is this is one place where states and localities are systematically disempowered along most of the natural lines because of Citizens United, and not just Citizens United, but a long line of Supreme Court cases. So I'll just say, it's really state and local financing that's the one sort of bastion left for states and localities to make a difference, and it is almost impossible to do in this political climate because politicians do not want to tell you that they're cutting budgets and they can't pay their pensions, but oh, by the way, you should fund their elections process. So it is a dark and horrible place, and campaign finance reformers have the worst lives possible. I don't know. I really have nothing helpful to say other than forget it, do something else.
I do.
Join Heather in her dark and horrible place. Well, David, Terry.
No, the federal Congress has blown it. The Disclose Act isn't going anywhere. But I think our biggest hope is at state and city levels. Austin, Texas has passed campaign reform, as Seattle, Washington. There are a number of local governments that have taken it on. I know we've got cities in Arizona that are looking at both transparency and the contribution side and some limitations consistent with Citizens United on the contribution side. I'm trying to do a local initiative in Arizona that would be a transparency initiative that basically would require the disclosure of the original source of all money spent to influence an election. It's a big chunk to say, but I think we need more of that, and I think it's going to come from the states.
I completely agree with Terry, and I think that the fight needs to be fought not just over transparency, but also in regulations that get at root at corruption, and corruption broadly defined. If anybody in this room who gets hounded as much as I do for campaign contributions and understands the way into politicians' offices is often through the campaign finance process, understands that you have to take a shower a lot of times after you've been through one of these situations. And at the state government level, there can be an opportunity to pass legislation and document these kinds of stories. I mean, remember the McCain-Feingold, the BICRA, Bipartisan Campaign Reform Act of 2000-2001 had almost no record to it, except that Senator Thompson had done this exhaustive investigative report. It was a very long exegesis on problems with campaign finance. And the problem right now that we have is that there is no mechanism or appetite at the national level to develop that kind of record where it needs to be done. So states have to develop that record and have to document the way that campaign contributions get made, what access that provides, and the like. And if it doesn't happen at the state level, it isn't going to happen.
Although
But
I just
it's-
want to,
it's-
oh, sorry, please,
No,
Justice, go ahead.
But you're asking the very people who benefit from the system to change it. I don't see that happening at the state level. And then even if we pass state reforms, it's not going to deal with the independent expenditures that funnel all of this money without any regard to who gave it. And it's just like a cash cow that they spread around to everybody they want.
So I'm in favor of transparency, but I do think that there is a way in which we put too much faith in transparency. We know a lot about the way monies were moving around, and it is scandalous, and it has not yet sort of moved the American people to change things. And so I'm all in favor of a little bit of more transparency, but I'm a little skeptical that it's actually going to move the dial. I'd rather see people fund candidates, give them sort of jumpstart candidacies by giving them enough money at the state and local level so they can run and move into these offices and eventually vote more things through at the federal level. But I am a little bit
Well, that's the
skeptical
main
about
system,
transparency.
and it was passed by initiative, as ours would have to be. I think you make a very good point about the legislators. Incumbents have a very hard time dealing with dark money. I think they either get it, they want to get it, or they're afraid of it.
That's right. Go ahead. Oh, okay. For those issues that state AG's offices won't take on and the federal government won't enforce, e.g. marijuana laws, police brutality, who should that fall to?
She's looking at me. She's going to hit me if I don't say cities.
The Yale Clinic.
No, so I do want to say, I want to say something about income redistribution. Because I think we have to have a conversation about taxation in this country. I think we have to have a conversation about funding in this country. Because what everybody always says is, well, there's no money to do this and there's no money to do that, as if it's not a choice we're making. And we're making that choice. And when President Reagan became president, he turned taxation into a bad word. Now, if you told any, cities are public corporations, as are counties, public corporations. If you told a private corporation, we can't give you any more money for research and development. You can't ever start anything new. And we don't really want to fund the things we're already doing and expect it to be profitable. That would be insane. Why in the world are we allowing that to be the conversation about public funding of all kinds of things, including enforcement of labor laws, including, not just potholes, basically, right? I mean, we have to be willing to pay for the government we want. And, when people talk about California and how great California is, it's nice to hear, but as a person who lives in Oakland, we have segregated schools, racially segregated and socioeconomically segregated public schools. The white kids are getting a much better education. The black and brown kids are getting a much, much, much worse education. We are tolerating that situation because we've decided as Californians about 30 years ago not to fund public education. That's a decision we made. And we're grappling with that now. So there's a lot of, the conversation about money is a very hard conversation because it needs to happen somewhere. And I feel like we need to basically start talking about, what kind of a community are we willing to buy for ourselves? And the reason I think that that is a resonant conversation at the local level is because you can point to the park that you'll have, right? And you'll say, well, are you willing to give up 2 of your 5 flat screen TVs if we could have a park, down the street that was nice that you could go to, right? You can have that conversation. But I think it's a conversation that we need to have. We just can't keep saying we don't have the money for things.
Yeah, but that conversation's about the credibility of government in general. And right now it's at a very low level. And so people don't want to put money into a process that they think is either corrupt or inefficient.
So we have to start talking about how the good things
we are
that
really
government
talking,
does.
and that's where, again, local government, and people give very high marks usually to their local school board, second their local city council, and then it goes down from there to Congress, which is in negative numbers. And I think that's an issue that has to be dealt with. The credibility of government is something Trump has taken on, and he's basically dominating that area.
It's a chicken and egg problem. We can't get really good at what we do so that we can get money, because then they'll say, well, you don't need money because you're already good at what you do. We have to start talking about this.
But can I just say, we need to change the conversation. I get so tired every time we have a national election. We're talking about we're going to tax people who make X amount of money to fund for this. It can't always be about income inequality and then a redistribution of that income from people
Public investment.
Okay, but let me finish. Because while it sounds good, right? Mm-hmm. The reality is, I was a kid of the desegregation, and while that sounded great, we're going to bus inner city kids to suburban neighborhoods to get schools good. While it sounded good in theory, nobody played it out. We thought that through a policy of suing school districts that we could force people to live together, and all we did was create urban ghettos because nobody thought through, well, if they don't want to go to school together, they're not going to live together. So what happened? We brought all these busing lawsuits, and all we did was we drove white people to the suburbs. We left poor people who couldn't get out in the inner city, which is why Oakland schools are bad, which is why the school that I came from is bad. So what I'm saying to all of us in this room, however well-intentioned it is, you've got to roll out the consequences. It can't just be that if we have more tax dollars and we take it from people like me who, I don't apologize for what I make. I worked my ass off to get here, and I don't want to pay more in taxes. I don't think that makes me a bad person. So we've got to figure out how to take the dollars that we're already sending to the government and figure out a way to make our communities better without demonizing people who make whatever they make and supporting people who need a leg up to get access to the middle class.
How do nullification efforts by red states affect progressive federalism?
Sorry, how?
How do nullification efforts by red states affect progressive
John C.
federalism?
Calhoun?
Sure. We'll move on to the next one. Does anybody know what that means?
Actually, I do actually.
Oh, okay, good.
There's a real question here. I mean, the question, and this is a question for everyone who wants to use federalism as a tool of resistance, and it's a question for both sides, is how far do you go? Right, so a lot of times when we talk about what you're doing with regard to progressive resistance or conservative resistance, depending on who you're talking about, you're talking about things that are within the bounds of the existing law. So for example, withdrawing state administrative support for a federal program that you don't want to take part in, right? That's perfectly legal. It's a form of resistance, it's a form of dissent, it's perfectly lawful. Taking a program in a direction that was unexpected, but nonetheless within the ambit of the program is also perfectly legal. So think about welfare to work, the Michigan and Wisconsin governors, who inside those own programs created a new program with the aim of destroying ultimately what the original program was about, but they did it in a fashion that was perfectly lawful, right? Those are different forms of resistance, but as you move out the bounds, you get to the point where you are actually thwarting, nullifying federal law, and you really need to think about when you cross that line. Because it's one thing to be an opposition party, but you need to be a loyal opposition party, right? There are limits in politics to the amount of resistance that you can put up against an actual national consensus. And if you don't believe that, think about what happened in the wake of the civil rights movement, right? It was death by 1,000 cuts. Right. It was not the actions of a loyal opposition. We had reached a national consensus, we had passed national statutes, and still we saw resistance. If you worry about that, and you should, then progressives should be careful about thinking about how far they want to go when they cross the line on resistance. Where is that line? And if you are part of the loyal opposition, what do you do when you disagree with the national government, and how far do you go?
So what do you mean by loyal opposition?
Well, loyal opposition is actually, this is an imprecise term for those, if there are academics in the room, they're going to start complaining in about a minute. In the British system, there's something called the loyal opposition, and the idea is that you share a little bit of power with the party from the other side because you recognize them to be a loyal opposition. And it came from the basic idea that you could be oppositional and still disagree. You could be loyal and still disagree with, at that point, the sovereign, right? So that's the idea. But what it's really about is how should politics work, and particularly in this moment when each side views the other side as a monster. When each side thinks that everything that the other side is doing is evil, when each side can't even process the same news story on Thursday, even though the facts were available to all of us and we watched it at the same point and came up with opposite conclusions, that's a real danger.
Absolutely.
It's a real danger for election law, and it's a real danger for federalism. Because if you think the other side is a monster, you're never going to give them the leeway that they need to do things in their own way. So what I mean by loyal opposition is recognizing that even if you want to go to war with someone, you don't have to turn them into an enemy. And I think that is a deep value of our profession. The thing that we train lawyers to do from the very first day they walk into the classroom is think about the very best argument for the other side and all of the weaknesses in their own side. That is something that lawyers, I think, have to offer politicians today, and that, to my mind, is what makes us an honorable profession, and we should imagine that in politics as well.
I want to make the point that where we have this big disconnection right now is that is over the role of values and norms in the way we choose to govern ourselves. We have rules that have elections, but there are a whole series of norms and values that go into how we're going to treat each other that are not necessarily written down. Let me give you an example. When a president in his term nominates somebody to be on the Supreme Court of the United States, it has been a norm or value that the Senate is going to have a hearing and then discharge its responsibility to vote on that nominee. And where I think that we have to come to grips is that our acceptance of certain norms and values has not been shared necessarily by everybody in the political space. And so we have to figure out what are the norms and values that are actually going to be accepted by everybody and be able to act on those, and while promoting the norms and values that we think a civilized society ought to abide by in governing itself. And that's the struggle and conversation that I hope you all will have, because I view that as a very serious problem. When we have leadership in the country now that won't either read the Constitution or talk about it, or talk about values as opposed to money, we're having a hard time, because we can't govern ourselves strictly by rules and adherence, coercion, remuneration. We have to have a normative structure, and that's what's breaking down right now. And I think it's incumbent upon all of us to try to find ways to rebuild those norms and values.
If I could just quickly add to that. I mean, I do think, and this gets back to the whole point of this panel, right? In that federalism has a very important role in setting those norms and values that you're talking about, right? So you can have proliferation of a norm across 25,000 localities in the United States, 50 states, and that helps create that culture or that norm. And that's, I think, what we're fighting about for progressives.
So this is a perfect segue to the final thing that we want to talk about, which is marching orders. And the reason that I think marching orders are so important is because the very, very best day of my professional life by far is the day that I met Heather Gerken. And I met Heather Gerken because of what she said during the marching orders part of a panel. So starting with Heather. So we have a room full of law students, law professors, private nonprofit or plaintiffs' lawyers, lawyers in traditional corporate law firms, and state and local government lawyers. So take your pick. What are your marching orders?
I just want to talk to students, actually. I'll just say, it's very simple. Be part of the loyal opposition. Remember that sometimes it's better to be the man than sue the man, and suit up and get in the game.
Terry?
Amen to that, but help your local attorney general, especially if they're standing in that loyal opposition. And I think this organization and its members can do a lot along that line. And I applaud the outreach that's already been initiated. I think the second half is a caution to law schools to pay more attention to, as we have discussed, the discussion of today's panel, which is to pay attention to people that are enforcing the law at the state and local level, because they have an incredible impact upon our future. And most national law schools, with the apparent exception of Yale, never thought I'd say that,
It's not your father's Yale.
Basically, yeah. You're sure right about that. But they have basically focused on Washington and focused on the Supreme Court and left the huge amount of jurisprudence and important activities for the lives of all Americans, which is state and local, completely out of their academic pursuits. And I think it's time to end that.
I think more just a general thought that there are other groups, restrictionists, conservatives, who've used the federalism platform to great advantage over the last several decades, and to be able to learn what was useful about that movement. And I think that's something that progressives are starting to do now, especially larger advocacy organizations, but to really double down on that effort to network, to have model legislation that you can proliferate in a way, because the battle is being fought here. There's not going to be large legislative victories at the national level. So this is where I think groups like ACS and all of those other large national groups can really make a difference.
And I would go back to the national consensus that has apparently delivered us to this moment, and to think about the caution we talked about earlier, because the precedent you create tomorrow can come back to bite you some years down the road. And then I would also just leave you with this thought. I completely agree that you need to get in the game, to whether it's offering yourself up for public service or working in cities and state governments to make a difference, but also to think about this. The reason we're at this moment is we still have a significant part of our country that does not engage in democracy, that does not vote. And many of us are always trying to speak for them. And what I would ask us to do is, instead of trying to speak for them, to find out why they're not engaging and see if we can get them to be participants in their democracy, because then we won't find ourselves in this situation if we can get people to the ballot box.
So when I finished clerking for Justice White, we were sitting around and talking about this sort of thing. What do you do? And he said, participate. Don't complain about the system. Get in and do what you can to make it better. Within the constraints of your life and your existence, just try to make it better, whether it's at the local level or whatever level you are. And I believe in that kind of participation, and that's what I would say.
So I am going to say, I'd like to speak to the law students and also the law faculty. We have 200 ABA accredited law schools in this country, and we probably have 20 or 30 full-time tenured or tenure-track faculty teaching who self-identify as state and local government scholars. We have even probably fewer law schools that actually offer, from a tenured or tenure-track faculty member, state constitutional law and state and local government law. And there's probably even fewer law schools that offer state and local government lawyering. So I would urge you to push your law schools to make one hire. I'm asking for one hire. One person who will come in and write about state and local government law and teach state constitutional law, state and local government law, and public lawyering, those three subjects. I actually think it would really go a long way towards starting law schools down a path where they're thinking about building out public lawyering capability and excellence from the ground up. So thank you very much. Thank you to the panelists. Thank you to the audience.